Hello, it is Thursday morning, 11 o'clock Pacific Standard Time, and I am Anne Michelle Francis with Handling Problem Tenants Like a Boss. So, this week's episode, I should call it, is going to be a little bit different than usual because I am answering your question, and I am answering the number one question that I'm receiving. So, usually people are calling me now because they've heard the moratorium's over. I personally have been showing up live every week for the last 19 months, telling you and giving you different strategies to get your tenant out. And I also said that it was actually easier to get your non-responsive, non-paying tenant out of the property during the eviction moratorium. And that is still a fact. It was still easier to have served a 15-day notice to a tenant who didn't pay a thing and then start your eviction. Starting October 1st, that is no longer an option. So for anyone who had the 15-day notices out there and they ended and the tenant didn't respond, then that's a whole different ballgame right now. So instead, we're focusing on the 3-day notices that are being served to tenants who didn't pay their October rent, because we knew that they wouldn't be paying their October rent if they haven't paid you rent for the last 5 or 6 months anyways. But today's episode is a little bit different because I want to focus on what happens if you don't want them to pay. So you have a tenant, your tenant hasn't paid you, they haven't paid October, they probably haven't paid months before that. But what do you do if you just want them out? You don't want to mess around and play games and try and get extra funding from the state. You just want them out of the property. So this is what I'm going to address today and let you know why it's a little bit tricky and why you have to choose. Because people come to me, and this was actually before the moratorium, during the moratorium, after. People want their cake, and I'm going to say this wrong. They want their cake, they want to eat it too. Did I say it wrong? Okay, whatever the right way is, post that for me, because you can't have a tenant in a property who's paying you and also tell that tenant to get out. Not when you're looking at an eviction. It is just not possible. It's not the way that it goes. Usually you want a tenant out for a reason, whether they're not paying you, they're breaking the rules, or you just want the property back. But people also want all of their rent and they also want the property back, right? So they want everything to go perfectly and smoothly. Well, sure, that's how it goes when you don't need an eviction. But what happens when you actually need an eviction? I'm going to pause for a minute because all 4 of my children just entered my hotel room and they know that I'm live right now. So I'm sure that they're probably going to even make an appearance and then they will go. So for those of you who don't know, I'm traveling with my children and that is what we do, which is why I'm in a hotel room right now. So anyways, they're about to take off. So with your tenants who owe the rent and you also want them out of the property, what you want to do is come up with a strategy about what that looks like. So first of all, you have to choose, do I want my rent or do I want my tenant out? You do have to pick one. So when you call me and you say that you have a certain scenario going on, I'm going to make you choose. Do you want your rent or do you want them out? Because you can't have both. So let me tell you why. So first of all, with non-payment of rent right now, post-moratorium, which is also the 7th and 8th trimester of the eviction moratorium that I've always been saying, right now you can serve a 3-day notice for non-payment of rent for October rent only. So only for October rent. We're not asking for any back rent. You'll have to go to small claims court starting in October to get any of that. We're just not messing with that right now. So right now is October rent, 3-day notice. So once you serve the 3-day notice, then the tenant then you also are required to apply for the rent relief program if you have not already. For months, I've been telling you, also apply for the rent relief program. Serve your 15-day notice, apply for the rent relief program. You need to do that now. So now it's come time where you serve a 3-day notice, and then you also apply for the rent relief program. If you haven't already, you want to apply on the same day you serve the 3-day notice because you can't start an eviction until 20 days have passed. We do not feel that it's clear what that 20 days means. So our office is interpreting it as 20 business days, not calendar days. So that means 20 days after your 3-day, in quotations, 3-day notice. Your 3-day notice is served. You have to wait 20 days before you can start the eviction because you also need to have time to apply for the rent relief program and make sure that your tenant knows that they have the opportunity to apply for the rent relief program, because our 3-day notices now are different. They tell the tenants about the opportunity to apply for the rent relief program. It gives them the website, the phone number so that they can get help. That's for any 3-day notice. It does not matter for any tenancy that began prior to October 1st, 2020. Anything after that is a little bit different, but there shouldn't be any tenancies that began October 1st where the tenant's not paying rent yet. Otherwise, someone didn't do their due diligence and you need a property manager. And so I can refer you to a good property manager if you're already in a situation where your tenant who just moved in like 14 days ago hasn't paid you rent. So assuming you have a 3-day, your tenant moved in prior to October 1st, Your tenant hasn't paid you or isn't paying you the October rent. We serve that 3-day notice. You also apply for the rent relief program. Then what? But what happens if you just want that tenant out? You don't want the money. You just want them out of the property. Well, then you're stuck because you have to apply for the rent relief program if you've served a 3-day notice and plan to start an eviction. I can't start an eviction because you personally, as the landlord, will need to sign and verify that you have already applied for the rent relief program before you can even start your eviction. So in order to start the eviction, the documents and paperwork we have to file prove that you have applied. And if the tenant's been unresponsive, then that's one thing. But if the tenant's responsive, then you're in it for the rent relief program. And then there are 3 outcomes that could happen from that. It could be your application's approved, it could be pending, it could be denied. The only way I can start an eviction is if it is denied. So again, a lot of applications sit pending for a long time because tenants are non-responsive. There is something that I can do about that. However, if you just have a pending application, it's only been 20 days, it's pretty aggressive to start your eviction after that. So we will need some declarations from you. So that's one thing, okay? Your tenant owes you the rent, but you're saying, I don't even care about the rent relief program. I don't want that money. I just want my tenant out. Okay, then let's talk about some other options. If you are not in a lease anymore and it is a month-to-month agreement, then you can serve a 30 or 60-day notice. It depends on where your property is. I am assuming your property is not a tenant protection ordinance property because then that would mean it's an apartment in the city of San Jose. The only other scenarios are, is your property covered by AB 1482? That means statewide just cause, or is it not covered by it? So your options are going to change depending on that. If you don't know what I'm talking about, then your property probably is covered by AB 1482, and it means you can only use a specific list of reasons to get your tenant out. So if your property is covered by that, then you can only issue a 60-day notice to your tenant for withdrawal from the rental market. That's really going to be the only one that you'll be able to use. So if you just want your tenant out, you don't want to deal with rent relief funds, you don't want to deal with an October, November rent being paid, then you want to go with a 60-day notice. If your property is not covered by AB 1482, you can still give a 30 or 60-day notice, but you need a reason, and it needs to be a good reason. And one of those reasons needs to fall in line with probably what AB 1482 just cause reasons are, such as withdrawal from the rental market. But you also have a little bit more options, but you have to make sure that your reasons are not discriminatory and they're not retaliatory. So a good reason would be to sell the property. So if your property is not covered by statewide just cause or AB 1482, then you can say that you want to sell it for selling, or you want to sell the property as a reason. Now, here's where the two come together, right? Your tenant hasn't paid you rent for a while. Your tenant hasn't paid you for a while, okay? And so you want to issue a 3-day notice. But really, at the end of the day, you just want your tenant out because with the eviction moratorium ending, you finally have that right again if your property is not covered by 1482. Or if it is covered by 1482, you have more options such as substantial remodel. You have a couple more options on the table. So no matter what, you have the option to get your tenant out with a 60-day notice now, but your tenant also owes you rent. So here's my advice to you. You need to pick. You need to pick, do you want that rent? Because if you get the rent and the rent relief program pays you, what they're doing right now is paying months forward. So if you need rent for October and maybe some back rent, they're not only paying that, they're paying through December. That means that you shouldn't be issuing that 60-day notice because they're going to be paying forward for that. So you're essentially canceling out that 60-day notice once you get the funding from the state. And I would not start an eviction for you if you were going before a judge saying, oh yeah, I gave them a 60-day notice, but I already got all the way funded and I refunded a month of overpayment of rent because I don't want them there anymore. You can't have all of it. Again, I'm gonna butcher that phrase again. You can't have your cake and eat it too. And that's essentially what it is. Sure, I want all the money from the rent relief program, but I also want my tenant out of the property. You can't do that. So you need to pick. Do I want to serve a 3-day notice right now and go through the rent relief program and get paid? Because a lot of landlords just want their money. Just pay them. They're happy to keep the tenants in the property as long as they pay. But a lot of you are done. A lot of you don't want to do it anymore. You don't want your tenants there. Your tenants are they are problems, but they're not problems enough to serve breach of contracts. And so then you need to pick that. You can serve a 3-day notice, but I will not start an eviction on it. And I don't recommend starting an eviction on it because then you would need to go through the rent relief program. And there's a very, very high chance that your tenant will qualify and get that rent because they're basically giving free money to everybody right now. They're in a mad rush to give that money out versus a 60-day notice where you serve that. If it's AB 1482, you have to give a month of free rent anyways. If it's not 1482, you just need to give a reason. And then at the end of 60 days, don't ask for the rent right now because you will be obligated to apply for the rent relief program. So those are the two scenarios. 3-day notice, apply for rent relief program, try and get your money. Or if you just want them out, a 3-day notice is not the way to just get them out anymore. Instead, you want to do a 60-day notice, a 30 or 60-day notice to get them out. Now, both of these scenarios require a professional. The reason I'm doing this video is because I'm actually answering these questions that I've been getting in the office, because people want to serve a 3-day and they assume an eviction's coming right after that. And it's not. Chances are very, very high that after the 3-day, you're going to get funded and then your tenant will be staying in your property. That's the whole idea of what the state has in place right now. However, with a 60-day notice, you are not obligated to apply for rent first. Now, I'm going to throw one more thing in here that's going to make it extra confusing, okay? So say your tenant hasn't paid you October, November rent, your 60-day notice ends, and we can start your eviction in December, okay? You have to sign paperwork confirming that this action is not about rent. That means you can't collect any of that October, November rent, any rent prior to the end of that 60-day notice. You can't collect any of that in an action through this eviction. Okay. Yes, you can get it through small claims court, but when you do choose not to go through the state's rent relief program and you choose to avoid the 3-day notice, you were also saying, okay, this action is not about rent. This action is solely because I want my property back and they're not moving out. So keep that in mind too, because those are some of the evictions I'm setting up, is that my owners are looking at the evictions. They're saying, wait a second, but my tenant owes me 6 months of rent. I want that in here too. I can't get that for you if we're starting it for breach of contract or we're starting it for a termination notice, because when you start an eviction based on either one of those, a breach of contract notice or a termination notice, you're saying, and the assumption is, the tenant is already current on rent, because tenants need to pay the rent to live in a property. So you're assuming, okay, everything else is fine. They're already paying the rent. And in addition to that, they're breaking the rules, or they're already paying the rent. But in addition to that, they're not moving out of the property. So that's why you can't ask for any rent in a lawsuit moving forward when it's on a breach of contract notice or a termination notice. So back rent. You can't ask for it from the day that that notice expires. Moving forward, you can't ask for any back rent. So don't be confused there either. Don't assume that once you serve the 60-day notice, once we move to the eviction, you're going to be able to collect all of that. You're not going to be able to collect all of that. We're starting over with a fresh case. If you want to be able to collect all of that, then the 3-day notice is your route that you want to go. Yes, you would have to apply for the rent relief program. If it's denied, we submit that to court and you would be able to get a judgment for all of that back rent. Okay. So I don't know if that's confusing or not. I don't know if that's clear for you or not. But I'm trying to break it down so that when people have these questions, it's a very high level that we have to understand this in our office. And so I'm trying to break it down so that you can understand it also, instead of me just saying, okay, I know how to do this. You just have to pick. Do you want a 3-day or do you want a 60-day? I want you to be educated about what the difference is and what your choices are when you choose one over the other. With a 3-day, you'll probably get paid back by the rent relief program. If not, and the application's denied, we start the eviction, but it's going to take time. 20 business days is a long time. That's almost a month. Then on the flip side, there's that 60-day notice. I don't recommend, you're essentially not collecting rent during that time period because you can't start an action against them for rent, because then you're back to the rent relief program and possibly getting that funding. So it's sort of this roundabout circle. But if you just want your tenant out, then breach of contract and 60-day notices are the ways to go right now. If you really want to get rent, if you really want to get reimbursed for rent, do it now, because these nonprofits are in a mad rush to get this money out to tenants. They are not qualifying them like they used to anymore because there's so much money. I can only imagine what this is going to do to our taxes later on. But once they get that money out, then the money is gone. And once it's gone, yes, you will still need to wait 3 days. You'll have to wait that 20 days, even though the money is gone, because that's what it's written in the law through March 31st, 2022. So be part of that. Get that piece of the pie. Get the money if you can. Otherwise, if you just need them out, if you just need the property back, if you just want to move in, if your sick mother needs her house back, whatever reason that is, then just do the 60-day and stop worrying about the rent. But don't do it on your own, because if you do it on your own, you're going to waste time. I promise you that. 9 out of 10 times the notices, actually, it's more than that. The notices are never right when they come in my office and tenants and owners are doing them on their own. I have to do them over. I have to do it a different way. It's very, very rare that it's done the right way the first time. So that means you're wasting the 3 days or the 20 days if it's non-payment of rent. And that also means that you're wasting 60 days if you're doing it for termination. Who has time for that? I don't have time for that. You don't have time for that. What is your money and what is your time worth trying to research these things that I am an expert on? So go to the experts for the information that you don't know how to answer.